the criminal penalties for certain violations of fleeing or attempting to elude a police officer when that person has a prior conviction for the offense. The bill amends KSA 81568. That's the statute that criminalizes fleeing or attempting to elude a police officer. Current law there in subsection B provides that a driver of a motor vehicle violates this statute when that driver knowingly fails or refuses to bring such driver's vehicle to a stop, or who otherwise flees or attempts to elude a pursuing police vehicle or police bicycle when given visual or audible signal to bring the vehicle to a stop, and either commits certain other offenses during that pursuit, is attempting to elude capture for the commission of a felony, or knowingly drives the wrong way into an opposing lane of travel, knowingly departs the appropriate lane, knowingly drives through an intersection, or causes a collision with another driver. A violation of paragraph 1 or 2 there is a severity level 9 person felony, and a violation of paragraph 3 is a severity level 7 person felony. This bill keeps the elements of the offense the same, but it changes the penalty on second and subsequent convictions. So violation of paragraph 1 or 2, it'll stay a severity level 9 person felony on a first offense, and then it would become a severity level 5 person felony on a second offense, and a severity level 3 person felony on a third or subsequent offense. And then violation of paragraph 3 will remain a severity level 7 on a first offense, and then it'll become a severity level 5 person on a second offense, and a severity level 3 person on a third or subsequent. And I can take any questions.
Questions, Representative Carmichael.
Thank you, Mr. Chair, and thank you, Ms. Scott. You know, one of the things we consider around here is the proportionality of the penalty in comparison to other penalties for crime. And so could you perhaps remind us severity level 3 person felony, which is what a second or I assume subsequent offense would be subject to. What other crimes fit within that, and where is that on that sentencing matrix?
So off the top of my head, I know kidnapping is a severity level 3. Involuntary manslaughter, DUI, I think it's while you're a habitual offender, I think is a 3. But I would note that the Sentencing Commission actually on their bed impact statement provides you with a proportionality assessment. So if you look at that bed impact statement, it'll probably tell you the crimes that are around that severity level. As for the grid, if you're a severity level 3, you're going to be presumed imprisonment regardless of your criminal history. That's a pretty high level offense. So,
do you know offhand how long we put people away for severity level 3, the range on the grid? I know that our vice chair has the chart usually at hand. There he is on the job. If he could share with the chair's permission, I'll take his word for it.
Go right ahead, Vice Chairman Smith.
Well, I know Natalie's better at this than I am. It depends on your criminal history, and that's why we have the grid. It looks like if you have no history, it could be as low as 55 months for a level 3. If you have an A level, you can move all the way up to 247 months.
That's what I needed to know. Thank you.
Further questions, committee? Seeing none. Natalie, thank you. Oh, Representative Vaughn has a question.
Thank you, Mr. Chair. Natalie, so currently there's a misdemeanor evade and elude charge, right? And then if you commit 3 or more traffic offenses while evading and eluding, it becomes a felony.
yes, so the misdemeanor, and I didn't describe anything related to the misdemeanor level offense, but if you look at subsection A, that's where the misdemeanor flee and elude is, yeah. We're only talking about the felony version.
Right. And so it seems to me that some of the conduct described in this bill would be other traffic offenses. So, you know, that would count towards the 3 other traffic offenses while evading and eluding. And so I'm kind of not necessarily tracking the purpose of this bill. And maybe might be a question for the conphrase.
Well, and I want to make sure, Mr. Chairman, that I didn't misspeak here. So we're not changing anything related to the elements of the offense. If you are committing the felony level, I think what Representative Mon is referring to are these traffic infractions. They're kind of on the first page of the bill, starting at line 26. Those are the infractions that they are. We're not proposing to change anything of that. But if you have a felony level flee and elude, and then you get a second one, right now, it's a 9, a 9, a 9, a 9. Now it's going to be a 9, a 5, a 3, or a 7, a 5, and a 3, depending on the version of the crime that you commit.
Certainly. Anything else for Natalie? I'm going to look 3 times to be sure. Okay, you're good. Thank you. All right, we'll now hear from Ed Klump on behalf of the Law Enforcement Associations as a proponent.
Thank you, Mr. Chairman, committee members. I am Ed Klump. I'm here on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. We requested this bill to address an issue, and I think you've all asked some really good questions about this bill. This statute is not easy to understand. This is my 3rd time of having a bill that we've been involved with over the years I've been doing this job, and it never is easy to understand. So I'm going to try to take a little bit of shot at that. But before I do, I want you to understand, and you know how dangerous vehicle pursuits are. They're dangerous for the officer, they're dangerous for the driver of the vehicle fleeing, and the occupants in that vehicle, they're dangerous for the motoring public, pedestrians, and everybody else involved. And unfortunately, even when law enforcement discontinues a pursuit because it's dangerous, many times we see those people continue to drive in the same manner they were driving when we were chasing them and end up in a very serious accident. Those things do happen. It's just a no-win situation. And there's only one person that puts them into that situation. That's the driver of the car that chooses to flee. That's why we're here, and that's why we want to fix this. So let me kind of go through the statute and explain the application of it. So in subsection A, those are the ones that the first offense is a B misdemeanor, second offense is a misdemeanor, third and subsequent then becomes a 9-person felony. So subsection A1 has 2 sections to it. It's A1A, A1B. And A1A is for that driver who never makes an attempt to really elude you. They just don't stop. It's different from the traffic infraction of failing to yield where you're supposed to pull over to the right. So in my experience, this violation here usually plays out like this. You try to pull over a car that you suspect of DUI. They don't stop. They don't speed up. They don't shut off their lights. They don't make turns trying to elude you. They just simply don't stop. And while they're doing this, they get on their cell phone and they call their buddies, and that's whose house they go to. And so when we get there, they decide to stop. You have about 10 people pile out of the house and want to fight with you. So that's this one. This isn't where they're doing any extraordinary traffic violations, creating additional danger. They're just not stopping. And then in A1B, it's where they make some level of attempt to elude. Maybe they shut their lights off, pull down an alley, but they're not doing those things listed in subsection B that are really hazardous when they do them. And so same level of punishment for both of those sections in A. So that's not what we're talking about in those bills. There's absolutely no change in sentencing or anything else in those 2 subsections. And then we get into B, and these are where the more dangerous offenses occur. And if you'll see in subsection B1, there is 6 events that the legislature has decided are so hazardous they deserve a higher level of penalty. And so when 3 or more of those occur, then it becomes this higher level. And right now, like the revisor said, it's a severity level 9 first offense, second offense, third offense, fourth offense, never stops. It's always severity level 9. And so the only increase in the penalties there is they move left across the grid as they get more felonies. So in the lesser offenses, we step that up for multiple offenses. So if you're a slow learner and you don't learn from that first conviction and you go to the second conviction, in the first subsection, we increase the severity levels. But in the ones that are the most dangerous and cause the most harm, we don't do that. It always stays a severity level 9. And then there's a subsection B3, which is currently a severity level 7. And that is, I'm trying to think what that is. It's a difference. I think that's the one driving the wrong way on a divided highway. And so that's an even more dangerous one. And we have a lot of fatal accidents when people try to do that. And believe it or not, when we stop people, you know what they tell us? They did that intentionally because they didn't believe that law enforcement would continue to pursue them if they did that, because it's so dangerous. They know it's dangerous, and they do it in an effort to get us to quit chasing them. And that's a severity level 7 person felony today for the first, the second, the third, and so on, all the way through. So what this bill does is it proposes stepping up those penalties for the slow learners that don't learn the first time, don't learn the second time, and don't learn the third or subsequent times. And that's the essence behind this. We think it's a very reasonable thing to do. And it's similar to what we already do in A, although not to the higher levels, because that's not as egregious a violation. And so I think with that, Mr. Chairman, I'll just stand for questions and we'll go from there. I hope that explanation was maybe add a little clarity to it. I don't know. It's not an easy one.
Questions for Ed? Representative Mon.
Thank you, Mr. Chair. Ed, I didn't see anything about this in the bill, but I'm just wondering, is there any implications on the bill that we passed last year about fleeing and eluding on foot? Does this implicate?
No, there's nothing in this bill on that, and that was intentional, because that's a whole different set of circumstances. That one we passed last year was to address the non-motor vehicle fleeing and eluding, and that presents its own set of dangers to everybody involved. So this bill has nothing to do with that. They don't cross in any way.
Would we wish to elevate second, third, fourth offenses for the fleeing on foot as well? I know that this is a traffic bill and it doesn't, but just thinking down the road whether we're going to see a corresponding bill.
You know, I don't recall now, and I see the revisor going to the computer, so I can't remember if we put something like that in that bill or not. But for right now, I'd say no. I don't want to mix these two topics together because they're quite different circumstances. When you're in a motor vehicle, the danger level to just the motoring public is so high. When those foot pursuits, it's a high level for us, and it's a high level of danger to the public because a lot of times these people are run into an unlocked house or into a business, and then we have, you know, hostages being held and stuff like that. So, different situation. Good question, though. Thank you for asking.
Additional questions? Representative Smith.
Thank you, Mr. Chair. Ed, how long were you in law enforcement active?
35 years.
35 years. You probably saw couple anyway, chases like this, where we talk about the danger level that's involved. In your experience, how many of those ended with them pulling over and putting their hands out the window versus a crash?
Oh, I don't know if I could put a number into it. In the pursuits I was involved in, I never had one that ended in a serious crash for a non-participant. I did see some serious crashes involving just the vehicle that was fleeing. But there were times when people would eventually figure out they weren't going to get away and would pull over. sometimes there was other motivation in that than that, but they would eventually stop for whatever reason. But today, late in my career, what we saw was they didn't stop and just sit there. They stopped and actually would bail out while the car was still going down the road without it, still in gear. And the car goes on down the road and they take off on foot, and now we have a foot pursuit. So, it's all aggregated. But, I think the thing to focus on in this bill is we have a person who produces an extremely dangerous situation to people. And there is no increase in the penalty when they do it twice, 3 times, 4 times, 5 times. And I think that's the importance of this bill.
And in fact, my county attorney just put somebody in prison for their 7th time flee and elude, but they got more time off possession of methamphetamine than they ever would see. And I've got the newspaper article I'd like to share with the committee at some point.
When I was an officer, we had a person here in Topeka. I don't remember the exact number now, but it was over 15 convictions for driving, for attempting to elude. And he finally went to prison. And after he went to prison, when he got out, which he didn't stay in prison long, but when he got out, we did not have another single case from him.
Certainly. Anything else for Ed Committee? Seeing nothing.
Thank you.
Thank you very much. I don't see any other proponent, neutral, or opponent testimony for House Bill 2666. And not seeing anyone bring anything new to my attention, we'll close the hearing on House Bill 2666. And we'll move on to House Bill 2665 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2665 increases the criminal penalties for a driver who leaves the scene of a vehicular accident when that accident results in death of any person or more than one person if the driver knew or reasonably should have known that that accident resulted in injury or death. The bill amends KSA 81602. That's the statute that criminalizes leaving the scene of an accident. Current law there provides that the driver of any vehicle involved in an accident resulting in injury to, great bodily harm to, or death of any person or damage to any attended vehicle or property shall immediately stop such vehicle at the scene of such accident and remain at the scene until the driver has fulfilled the requirements of KSA 81604, which that statute requires the driver to give certain information after an accident. Current law penalties there provide that violation of the offense is an unclassified misdemeanor if the total property damage is less than $1,000. It's a Class A person misdemeanor if there is injury to any person or total property damage of $1,000 or more. A severity level 8 person felony if there's great bodily harm to any person. A severity level 6 person felony if death to any person occurs. And a severity level 5 person felony if death of any person occurs and the driver knew or reasonably should have known that that accident resulted in injury or death. A person's driver's license can also be revoked for a violation of this section. This bill would keep the current penalties except for in the instance of death when the driver knew or reasonably should have known that the accident resulted in injury or death. So the current law there provision would go from being a severity level 5 person felony to a severity level 4 person felony. And then a new provision is added that when death of more than one person occurs, and again, the driver knew or reasonably should have known that the accident resulted in injury or death, then that penalty would be a severity level 3 person felony. And I can take any questions.
Questions for Natalie, committee? Seeing none, thank you very much. All right, we will start off with our proponents and start with Chief Darrell Atterbury, Bel Air Police Department, on behalf of the Kansas Association of Chiefs of Police and the Kansas Peace Officers Association. Welcome back to committee, Chief.
Thank you very much. Chairman Owens, committee. I'm here representing the Kansas Association of Chiefs of Police and the Kansas Peace Officers Association, and we are proponents for this bill. Nationally, and in the state of Kansas, we're seeing more and more people fleeing from us, but also fleeing crashes. It's something that I've seen throughout my career. And the crashes involve oftentimes serious injury which is addressed here in this statute, and often death. And sometimes they involve situations that Mr. Klump just testified to, the high speeds and so on. But some of these crimes are very difficult to investigate. These hit and runs, and that's what they are. They're fleeing the scene of a serious crash. And it's only through the work of very tenacious investigators that we're able to identify who the suspects are and hold them accountable. And so in my testimony, I put in some points that I thought were important to let you know what types of offenses people are committing when they flee the scene of a serious injury or fatality crash. And it's a serious thing. I'm being facetious, but they don't have their driver's license with them. They might have a suspended driver's license, a revoked driver's license. Maybe they've never had a driver's license before. They might have outstanding warrants, felony, misdemeanor, or worse yet, they think they have warrants and they don't. They might not have insurance on their vehicle, or they're driving impaired, alcohol, drugs, prescription, or illicit. And one of the big things is that they just fear taking accountability for their actions. They don't want to stay at the scene and admit what they've done and take the penalty that's going to be there for them. Those are all examples in our assessment of people not taking accountability and being responsible for their actions. I've sat in on a lot of interviews and actually interviewed a lot of people who have been involved in hit and run accidents, whether they be serious injury or fatality in my career. And that is a common theme. They want to push the blame onto somebody else and not take accountability for their actions. They oftentimes feel as though that if they can hide their car long enough, the one that was involved in the crash, if they happen to get away in it, or their vehicle, and if they can lay low long enough, then the police will go look elsewhere for the next newest criminal, instead of them stepping forward or just giving themselves up to take accountability. The reviser did a good job of explaining the penalties, the increase in penalties for the death of somebody involved in one of these type of crashes. It does not increase the penalty for somebody seriously injured in a crash, because sometimes people are injured so badly they never recover. So you might consider that in future legislation. The KCP and KPOA would also like you to consider one change, and thank you to Representative Carmichael for reminding me. This would be proportional to this situation. We're not talking about, what I'm talking about is in Section 1C, where it says the director may revoke the license or permit to drive or any non-resident operating privilege for any person so convicted of any violation of this section. And we would suggest that that be shall, because we are talking about the death of somebody. We're not talking about an outstanding warrant. They fled because they didn't have their driver's license with them. They killed somebody. So we would like you to look at that may to shall. And with that, I'll stand for questions.
Committee questions for Chief Atterbury. Representative Carmichael.
Actually, Mr. Chairman, my question now is of the reviser based upon the proposed amendment, with your leave.
Sure.
I'd just like to verify with the reviser that if we made the change suggested by Chief Atterbury, does that only relate to fleeing the scene of a fatal accident, or would it be broader in its application?
Mr. Chairman, if you simply made the change as Chief Atterbury described, it would be for any violation of this section. So, but it would, of course, be possible to limit it to the new provisions if you wanted. However, I do want to know, I would want to consult with our transportation revisers. They do a lot more of the administrative stuff on driver's licenses, so I would want to talk to them about how to properly draft that amendment.
If I may, Mr. Chair, so at least as presently proposed, your best guesstimate or whatever would be that if we made that change to shall, it would be mandatory revocation for the misdemeanor versions of this crime as well?
Yes, I mean, if that simple change were to be what was made, then yes. However, I don't, it doesn't say in here anything about the length of the revocation or anything. So I kind of want to talk to the transportation folks about how long this has been around and how it's currently being used now.
Just for folks' information, I'm not proposing that amendment. Others may want to, and obviously the reviser stands by ready to help.
Additional questions for Chief? All right, thanks for standing there just in case. We'll now hear from Sheriff Jeff Easter, Sedgwick County, on behalf of the Sheriff's Association. Sheriff, welcome back to committee.
Thank you. Good afternoon, Chairman and committee members. I'm Jeff Easter with representing the Kansas Sheriff's Association. So throughout my career, I have seen cases exactly what we're describing here. And generally, in those cases, the reason they fled is because they're impaired. And there's a loophole in the law, is what this is trying to fix. That loophole is if you flee the scene of a fatality or near fatality accident, it's this severity level. If you stay on the scene, we can prove you're drunk, you're looking at vehicular manslaughter, which is a lower level, severity level. In most of those cases, that's exactly what we saw. Now, here's the difficult part. Generally, what I've seen is individuals that leave the scene 4 or 5 hours later, they come back because we're still working the fatality accident, try proving they're drunk. Because we have to establish probable cause that we see some type of an impairment. And if you do not see any impairment, you can't start a DUI process, period. You can't draw blood, you can't do anything. And that has been, unfortunately, I'm not from Mr. Carmichael as an attorney, but there's been some attorneys that advised their clients before to do exactly that. And so the problem that leaves us then is then we have to try to follow up, because you'll hear stories, oh, they were at a party, they were at a bar, they were at wherever, Super Bowl party last night. And then we have to follow up with witnesses, which is their friends, to tell us, oh yeah, they were drinking. But that still doesn't establish that they were drunk. The other thing that I've seen in my career is when we do follow up, have a tag, and we go to their house, and we knock on the door, they're sitting in there sipping on a beer or something else, and then how do we prove they were drunk? We can't. And so those are the issues that we face when this occurs. In Wichita, just in the last week and a half, we've had 2 fatalities where they fled. And so this is a common occurrence. One of the things that I will tell you is that Ms. Jill Ward will get up here in a second and she'll give you her story. So in full disclosure, I've been personal friends with her, her family, and her deceased son for over 20 years. The other young man that was killed in that accident, I coached in football for 5. So I do have a personal interest in this, so I'm just giving you that full disclosure now. What this bill will do is it will increase the severity level or decrease it from a severity level 5 person felony if the driver knew reasonably, should have known that such accident resulted in injury or death is a severity level 4 is what the proposal is. The brand new section is section B, subsection 6, is an entirely new section which states the death of more than one person if the driver knew or reasonably should have known that such accident resulted in injury or death is a severity level 3 person felony. That's the same as vehicular homicide. And so that's what the KSA is supporting, and hope that you pass the bill out of committee. And with that, I'll take any questions.
Certainly. Representative Eric Smith.
Thank you, Mr. Chair. Sheriff, you stated that you have to prove that they were under the influence. In fact, you have to prove that they were under the influence at the time of the accident and what that level was, correct?
Correct.
At the time of the accident. So 4 or 5 hours later, they may show up and smell like alcohol, but that doesn't give you anything for 4 or 5 hours ago, correct?
That's correct.
Thank you.
Further questions? Representative Carmichael.
Thank you, Mr. Chair, and thank you, Sheriff, for acknowledging that I have not given that type of advice. Quite frankly, in 43 years, so far as I recall, I never represented anyone on a DUI. That wasn't my line of work. But my colleague over here to the left, the vice chair, is in fact correct that not only is a blood alcohol taken 5 hours after the accident really not worth the paper it prints out on. Similarly, and this happened in my district 30 years ago, a lawyer on his way home missed it on the curve, hit the tree in front of a former municipal court judge's house, and by the time the law arrived, they were both sitting on the judge's front porch having scotch in the afternoon. That screws up the prosecution as well.
Correct.
Okay. I can see some need here. I'm not entirely sure about the proportionality questions, but I understand what you're trying to stop.
Further questions for Sheriff Easter? Seeing none, thank you. We'll now hear from Jill Ward, private citizen. Jill, thanks for being here.
Thank you, Mr. Chairman and members of the committee. My name is Jill Ward, and I am here today to talk to you about my only child, Levi, who was killed Easter weekend 2022. Levi was 20 years old, studying meteorology at KU, and was a first alert storm chaser for our ABC affiliate, Cake News in Wichita. His entire life, he was described as genuine, kind, and polite. And I know every parent wants to hear that their child is described in that manner, but in his 20 years, those 3 words were repeated to me over and over, whether it was from his high school football buddy, a high school teacher, or the stranger he met 5 minutes ago. Levi came home Easter weekend, and we decided to stay in and cook dinner together, and I got to spend 1 hour with him one-on-one. And he was off to see his childhood friends. So he got up, gave me a hug, kiss, told me he loved me, and that's the last I've seen of him. Levi and his friends were headed back to his apartment when a truck pulled out in front of them. I've read the accident report and every supporting document relating to the crash. I've watched all 27 body cam videos of the scene of the accident, and I watched my son die on camera. I watched his friend be transported to the hospital, and I watched him die an hour later on the operating table. The driver of the truck that hit him did not call 911, did not render aid, and left the scene of the accident. His dad brought him back to the scene hours later, dressed in different clothes. The accident report said an open bottle of whiskey was in the driver's side door, and he was charged and convicted with leaving the scene of an accident resulting in a fatality. The judge gave him the maximum sentence of 34 months, and he is scheduled to be out in 25 months for killing 2 people. I'm here today to talk about a bill that would revise the Kansas law that governs leaving the scene of an accident resulting in a fatality. The current law has this listed as a level 5 felony on the Kansas sentencing grid. For context, the Kansas sentencing grid includes 1 through 10 of felonies and has 3 sections. The first section is presumptive imprisonment, which is severity levels 1 through 4. The second section is the border box, severity level 5 through 6, where a judge gets to decide if they go to prison or just get probation. And the final section is presumptive probation, severity levels 7 through 10. Leaving the scene of an accident resulting in fatality is currently listed as a level 5. We know the main reason people leave the scene of an accident is because they have been driving under the influence of drugs or alcohol. If someone is charged with a DUI that resulted in a death, that is involuntary manslaughter, which is classified as a level 4 felony. No option of probation, and the length of prison sentence increases. The current law incentivizes people driving under the influence to leave the scene, which results in a lesser sentence for them, and more importantly, can result in the death where someone otherwise could have lived. In my son's case, the driver left two 20-year-old kids on the road to die. What if that had been a school bus of kids, or all of the rural counties in our state? If someone is left in critical condition, it could be hours before they are found. Minutes can be the difference between life and death when someone has critical injuries. There are two changes proposed in this bill. The first change is to move leaving the scene of an accident resulting in a person's death from a level 5 to a 4, which is the same as involuntary manslaughter and takes away the option of probation. The second change is in the event of multiple fatalities to further increase the severity to a level 3. I want to thank you for your time today. I appreciate you allowing me to tell my story in hopes of educating you on a loophole in the current law. Writing a sales pitch about my son's death is not easy, but necessary. I hope you will look at this situation and view it as a simple and fair change that will help provide accountability under our laws. Thank you, Mr. Chairman, and I'm happy to stand for questions at the appropriate time.
Thank you, Jill. Very sorry. Committee, any questions for Jill? All right, seeing none. Thank you. Committee, there's also written-only proponent testimony from Mark Bennett, District Attorney, Sedgwick County District Attorney's Office, and I don't see any neutral or opponent testimony that has been presented. With that in mind, yep, Representative Mon. Okay, Sheriff Easter, I believe Representative Mon has a question for you.
And maybe this would go to Ed as well, but so I see what we're trying to do here, and I'm fully in support of that. But my concern is when somebody doesn't cause the accident, so they're not at fault, and maybe they leave because they have a warrant or something like that. So they didn't actually cause the death of the people. Maybe somebody did die, but they leave. Is there any exception in the law, or should we put some exception in the bill for situations?
When you're talking about that, you're talking about they weren't at fault for the accident?
Correct.
Okay. You know, I'm just going to revert back to my law enforcement aspect of it is, don't they have a duty as a citizen, as a caring person, to at least call 911? Don't they have a duty to try to render aid whether they have a warrant or not? My belief is no. Whether they're at fault or not, you flee that scene, in my mind, it's because you were drunk. Plain and simple.
Absolutely have a duty to stay and render aid, and I get that. But during my career, I've encountered people who fled simply because I've got nothing to say to the law enforcement. I mean, literally, that's what I've been told by a client. I said, he didn't have a warrant, he didn't have a suspended license, he wasn't drunk, but he fled. And I'm like, why? And it's just a cultural thing. He said, okay.
I think it's much different when you leave a fender bender than when you leave two young men on the concrete dead. I think that's a total different difference there, or a big difference there.
I just think that there might need to be a step down when they weren't the cause of the accident. I mean, they weren't at fault in the accident. There is a duty, and I get that. But did you kill them, or was there an accident and somebody died? And I don't know, just kind of struggling with getting my head around it. All right, thank you.
Answer.
Further questions for any of the conferees committee? All right, seeing none. Thank you very much, and we will go ahead and close the hearing on House Bill 2665. And we have 3 bills currently up for final action. So we'll start out with House Bill 2656 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2656 creates the crime of engaging in a street stunt. It also provides criminal penalties for that new crime, and it adds the new offense as a method of committing, fleeing, or attempting to elude a police officer.
All right, committee, are there any amendments or discussion as it relates to House Bill 2656? Representative Smith.
Thank you, Mr. Chair. I move that we pass HB 2656 favorably from committee.
All right, do I have a second? Representative Thompson seconds. Committee, questions or discussions on the motion? Representative Carmichael.
Thank you, Mr. Chair. I think I'm going to go ahead and vote for this legislation. I think that Mr. Klump made a persuasive case for a problem that is very prevalent in my community. I don't know that it's a problem necessarily everywhere in the state. The one thing I do wish that maybe I or someone would have taken the initiative, and perhaps there'll be a time if and when this reaches the House floor, I don't think the type of conduct that's prohibited by this bill is a stunt at all. I think it's some other kind of conduct, and that stunt doesn't properly describe it. It's a lot more serious than somebody doing a wheelie on their motorcycle and pulling a stunt. I just can't think of the right word right now, but I hope people will take that, keep that in mind if this bill reaches the floor. Maybe we ought to find a better way to describe this criminal behavior. Thank you.
Further discussion, committee. All right, Representative Smith, you may close.
I close.
All those in favor of recommending HB 2656 favorably say aye. Aye. Opposed, no. The ayes wishing to be recorded are Representative Carmichael and Representative Martinez. All right, committee will now move on to House Bill 2630 and ask Natalie to give us an overview of that.
Thank you, Mr. Chairman. House Bill 2630 amends the rules of evidence to allow history of previous domestic violence offenses to be admitted during the course of a prosecution for a domestic violence offense.
All right, committee, are there amendments and or discussion as it relates to House Bill 2630? Representative Titus.
Thank you, Mr. Chairman. Just I have a motion, but to share some thought on this before I make the motion. I asked research to pull the statutory history that was involved in this bill. So it was changed in 2009, and that's when we added the exception for the sexual crimes. And that the context around that decision was markedly different than the discussion we had in the hearing. So we added the exception for sexual crimes because of a 2009 Supreme Court case, State v. Prime. And the discussion in that case was primarily around sexual abuse of children. And the Supreme Court actually asked the legislature to put this exception in because at the time there was numerous studies and scientific evidence that pedophilia actually did show a propensity to create crimes again, and therefore this was a special type of evidence. Similar rule was also in place in the federal rules of evidence at the same time. So understanding that this bill is well intended, and I think we're all concerned about domestic abuse and making sure people are protected. I don't think we've had enough background on this. Given that context, I don't think this is similar enough to the only other exception to the rules we have on admissibility. So with that in mind, I would move that we table House Bill 2630, and I ask that the chair request the Judicial Council further study this proposal.
All right, there is a motion from Representative Titus. Is there a second on Representative Turk? Is the second. Further discussion on this amendment? Representative Carmichael.
Just very quickly, I commend my colleague from Wamego for his diligence in looking into the legislative history. As he does point out, this is a somewhat unique proposal in the rules of evidence. And before we make this change, and it may well be a valid one, I think a good trip to the Judicial Council to really explore the significance of not only an exception to KSA 40 or KSA 60-455, which is well-established law, but I think it's probably also of some import that we be careful about what the standard of proof is for the admission of these prior offenses in a criminal trial, whether it's beyond a reasonable doubt, or whether because they're not charged with this prior crime, whether or not it's more probably than not, or some other standard. And I say that so that if and when the Judicial Council takes this up, they will be aware of this additional concern. Thank you, Mr. Chair.
Representative Eric Smith.
Thank you, Mr. Chair. I don't offer this in opposition to what you're suggesting so much as I think that the view on this from a purely legal standpoint and legal theory is rather, it'll be helpful as long as it occurs quickly. In 2010, I attended training with KBI to go out and become an instructor to other law enforcement agencies on the crime of stalking and putting kits together for folks who are the victim of stalking and rape. Stalking, to me, is very much similar to domestic violence in that it often occurs between two people who have been in a relationship, but it requires a course of conduct. And I think that would lend to the idea that in domestic violence, the course of conduct is very, very important when you look at what the ultimate, once they're caught, and I mean once they're caught, meaning that they are not caught the first time, they're not reported the first time, it was an aberration as far as the victim is often concerned. And so it will be the second, if you're lucky, but it'll probably be the 9th before somebody says, I can't do this anymore, my kids have seen enough. In those cases, I don't think legal theory is enough to support what should have happened on crime number 2, or that crime number 2 should have been included in the testimony or allowed in the testimony. Because it's very, very important to those folks that are living the life. So, again, I'm not in opposition to the Judicial Council taking a look at this and vetting it out. At the same time, let's make haste, get it done if that's what we're going to do.
Further discussion. Representative Vaughn.
Thank you, Mr. Chair. And we're talking on the motion now, not on the bill, right?
Correct.
I'm not sure what the Judicial Council will actually be able to provide us with. Because, first of all, this is we're talking about changing the rules of evidence for a very specific crime. And frankly, the priors go to sentencing, or should go to sentencing as an aggravating factor, not necessarily as evidence. I know we're not talking about the bill, but this bill worries me because it's kind of the line of questioning of when did you stop beating your wife? It's using one incident to prove the other, and it just goes against our normal system. And so I'm not sure that the Judicial Council will be able to help me resolve that. So.
Further discussion. Representative Titus.
Thank you, Mr. Chairman. Representative Mon, to your concerns, in reviewing the material, it was a similar problem with the particular case in State v. Prine, that they couldn't get the prior sexual abuse in because they said the mode of operation or mode of conduct wasn't similar enough to make it relevant enough over the prejudice. So I think the Judicial Council can look at sort of some of the studies behind domestic violence and show us if there is something different other than the current standard that could still allow these to be put in. I would emphasize, right, it's not that you can't have these admitted currently. There's just a high bar that has to be overcome. And I think we need to examine if there's some underlying psychology behind that would justify the exception, would be my hope.
Further discussion. You may close.
I close.
All right, committee, all in favor of the Titus Amendment, say aye. Aye. Opposed, no? No. The ayes appear to have it. The ayes do have it. Motion carries. We will table that bill, and Natalie or Jillian, if you'll remind me to ensure we get that request sent to the Judicial Council, I would appreciate that. Any votes wishing to be recorded? Very good. We are tabled House Bill 2630. We'll now move into House Bill 2353 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2353 increases the amount of time a person can be held for treatment, and it adds criteria for when continued treatment can be ordered under the Care and Treatment Act for mentally ill persons.
Very good, committee. As we heard on this bill, there were 2 amendments that were requested. And if you guys will recall, one of those amendments they worked on all year long in the interim to get prepared. So if we could get that amendment sent out. Yeah, go ahead and send both, because the other one is the technical amendment that just adjusts the dates because this was introduced last year. So let's go ahead and send both of those amendments out. So while that's out, I'll just recall and remind everyone that this was the legislation and the amendment that actually brought every single person into support of this bill. And they were all very grateful to one another for taking the time to work together to make this bill make this amendment work within the confines of this bill. And so while that's being sent out, I will move my amendment. Do I have a second? Representative Eric Smith seconds. And now we'll wait for it to come out for discussion. All right, committee, I believe the amendment is in your inbox. Correct. Give everybody a second to look that amendment over, and then I'll ask for any discussion. All right, committee, is there discussion on the amendment? Seeing none, I will close on my amendment. All in favor of the Owens amendment, say aye. Aye. Opposed, no. All right, the ayes have it. Those wishing to be recorded are none. All right, the next amendment is House Bill 2353, or excuse me, amendment on 2353, the technical amendment, which simply changes it from 2022 to 2023. You guys should all have that in your box. I will move that amendment. Do I have a second? Representative Turk, seconds. Committee, any discussion on the technical amendment? Seeing none, I'll close on my amendment. All in favor of the second amendment, say aye. Aye. Opposed, no. The ayes have it. All right, so we're back on the bill. Committee, further amendments or discussion on House Bill 2353? Do I have a motion as it relates to House Bill 2353? Representative Eric Smith.
Thank you, Mr. Chair. I move that we pass HB 2353 as amended out of committee.
Very good. Do I have a second? Representative Thompson seconds. Further discussion on House Bill 2353? Seeing none, close on your motion.
I close.
All those in favor of passing HB 2353 out favorably say aye. Opposed, no. The ayes wishing to be recorded, Representative Carmichael and Representative Martinez. All right, committee, that concludes our work for today. We'll see you guys again tomorrow, and